call this meeting of the Town of Clayton Board of Adjustment to order. Our first item on our agenda is the oath of office, and I understand that has already taken place, so it will not take place tonight, but we are pleased to welcome a new member to the board tonight, Ms. Ruth Anderson. Ruth was sworn in yesterday due to some scheduling conflicts with the town clerk, but it's my pleasure to welcome Ruth Anderson to the Board of Adjustment. And Ruth, would you like to tell us anything about yourself?
Do I hold this down while I talk?
You do.
Okay. It's my pleasure. Thank you, Marty, for the welcome. And I've lived in Clayton over 40 years, been involved in construction and development, so I'm excited about serving.
Well, we are happy to have you here, so welcome to the Board of Adjustments. All right, third item, adjustment to the agenda. Any adjustments? Thank you, Ben. Number 4, approval of the minutes of the June 15th, 2022 Board of Adjustment draft minutes. I assume everyone's had a chance to review those, and are there any corrections to be noted? The only thing
I'll make a motion unless you have a change.
I had one thing. I noticed on the minutes at the top, the council present, that may have, should read maybe board members present. It has our names under council present, so that's the only thing I saw. All right, I'll entertain a motion to approve the minutes.
So moved.
I have a motion by Mr. Perricone. There, a second.
Second.
Second by Mr. Anton. Any discussion? Okay, all in favor say aye.
Aye.
Opposed? Motion carries. All right, number 4, we have no public hearings, no old business. Moves us down to new business, approval of the 2023 meeting schedule. Ben Howell.
Good evening. So your 2023 meeting schedule is the same as it has been. So we're sticking with the third Wednesday of the month. So again, just ask that you approve that meeting schedule, and so we can get it posted and make sure all the meetings are out there for the public.
Okay. Entertain a motion to approve the 2023 Board of Adjustment meeting schedule.
The motion to approve.
Yeah, I have a motion by Mr. Anton. Do I hear a second?
I'll second that.
Second by Ms. Berry. Any discussion? Okay, all in favor say aye.
Aye.
Opposed? Motion carries. Next item, 7B, Board of Adjustment training update. Ben Howell.
Okay. And you're stuck with me tonight. I gave Raz a night off. But he did send along some material that I'm going to hand out to you. And I'm handing out a packet from Raz that's a conglomeration of different things that he has put together. And then also I have another sheet here that those of you who attended the Board of Adjustment training from the School of Government may have received this as well. It's just a list of reference materials from the School of Government. So let me hand those out.
Thank you, Ben. Thank you.
So just as you'll see there on this front sheet, it's a overview of, really just local quasi-judicial proceedings versus legislative actions. And as you go through the packet here, it's just a He goes through provides some of the QJ standards regarding no ex parte communications, things from the general statute. Also talks about legal standards for the decisions, findings of fact. And then he does include some of the excerpts from the general statutes that govern quasi-judicial decisions. General statutes are always very fun to read. Then there's some information towards the back of the packet, things from the school government regarding background material for Board of Adjustments, for different information about the roles and the type of decisions you make and the issues. And then towards the very back is a sample findings of fact document. Many of you who have been on the board have seen these. Ms. Anderson, you'll see these soon enough once we have an item to hear. And then at the very end, you'll see a couple of Coates Cannon's blogs from the School of Government. And anyone can sign up for those. If you go to the UNC School of Government website, they have a planning and development microsite, and you can sign up for their Coates Cannon's blog, which is pretty interesting. It has a little bit of everything come across it, but they do fairly regularly post information about planning and land use law information on there. One other thing I was going to try, get it pulled up. So I've recently gotten connection with the American Planning Association. They have some training materials for a lot of different things, but one of the materials that I was able to pull down was planning officials training. There's a lot to this, and this particular training is really meant more for planning commissioners, but they do have a couple of modules that are more specific to things that the Board of Adjustment talks about. And so I was going to at least try and play one of those tonight. Some of them are, 20 and 30 minutes long, but I did find one. I think there's one on here about findings of fact. I was going to try and play for y'all. It's only about 12 and a half minutes. This works.
The Planning Officials Training Program was developed by seasoned planners from across the country, all experts in training local planning officials. It is supported and presented by the American Planning Association, the national organization that is devoted to creating communities of lasting value forever. Our more than 40,000 members are made up of planners, commissioners, public officials, educators, students, and engaged citizens who are committed to creating vital communities. 4% of our members have obtained required education, professional experience, and passed a rigorous exam to become certified by the American Institute of Certified Planners. The Planning Officials Training Program aims to provide the essential information, insights, and sound practices applicable to better decision-making for those who serve as appointed planning and zoning officials for their communities. The use of planning officials throughout the presentations is a universal term used to group audiences of elected and appointed officials, planning commissioners, and boards of zoning appeals. Each state may vary on the term used to distinguish these members. For that reason, this program references planning officials and commissioners interchangeably. Throughout the videos, we use terms to describe these officials and their actions that may differ from what is used in your state. Though the terms may differ, the lessons are universal. There is no one-size-fits-all training for planning officials, so check local state codes or state enabling legislation for relevancy to your community. If there are any questions about what is appropriate or legal in your community, we encourage you to ask your local staff.
Hello, and welcome to Planning Commissioner Training. I'm David Silverman. I'm a partner at Ansel Link in Chicago. In a prior life before becoming an attorney, I was a practicing planner. I'm going to be going over various legal issues that you as Planning Commissioner need to concern yourselves with. And whether you're seasoned or whether you're new to a Planning Commission, we hope that you find this material helpful as you proceed with serving your communities in the very important role of being a Planning Commissioner. So it's important to understand that a lot of what you do is shaped by state laws as maybe defined better through court cases, and how those legal principles, which are derived both from statutory law and again through case law, shape your role and how you operate as a planning commissioner. The first thing we're going to talk about is findings of fact, making findings of fact, and the importance of making findings of fact. We represent a number of communities, and I can tell you in our own experience, it varies. But one thing we try to emphasize is the importance of making good findings of fact for what you glean from public hearing processes. We'll also talk about ethics. So, with any form of zoning relief, there is a set of standards that an applicant needs to demonstrate in order for a planning commission to make a recommendation to the corporate authorities, your mayor, your village board, your mayor, your city council, whatever it is. That's your role. Your role is you have delegated authority from the municipal legislature to hold public hearings and make findings of fact so that you can make an informed recommendation. And findings of fact and standards, these terms kind of get bandied about kind of carelessly, frankly, and I'm guilty of it too. But really, ultimately, at the end of the day, you're making findings of fact based on a set of standards that are outlined in your zoning code. So, the purpose of the findings of fact is not only to, frankly, constrain your operation as a planning commission, because your jurisdiction is limited. Your jurisdiction is specifically provided for in your zoning code, and sometimes again by state statutes. But they are designed to elicit information on matters of import pertaining to the type of relief the applicant before you is seeking, special use permit, sometimes also known as a conditional use permit, a map amendment, so known as rezoning, maybe a text amendment, in rarer cases, variations if those fall under your jurisdictional purview. But they balance the rights of property owners and the needs of the community. And again, they constrain your jurisdictional authority so that your recommendations don't go up to the legislative body in an arbitrary, capricious manner. So they help frame the discussion you're going to have in your public hearing between you and the applicant and members of the public who choose to come in and provide their own testimony. They're also designed to ensure for a fair process and a predictable, not a guarantee of the result, but a particular predictable decision-making process. They also should align with the goals and objectives of the comprehensive plan. And you, as a planning commissioner, have an expectation, a very reasonable expectation that any applicant coming before you for whatever relief is going to be prepared to show that the standards for the evidence they're prepared to present, the evidence that they may be asked to present in response to concerns from the public, and any questions you, as a planning commissioner, may have about their application. It's very good when you close a public hearing and you're in your deliberation phase, trying to determine the recommendation you're ultimately going to make to the legislative body of your municipality, to refer to those standards. Again, they are a good way to frame the entire conversation and ultimately the vote on a recommendation. It's also essential to have good findings of fact that meet the standards of your code as well as state law, in the event that a decision is ultimately going to be litigated between the municipality and the property owner, or perhaps even objectors to the relief that was granted. So some common examples of standards for findings of fact are compatible with the trends of development in the area, the neighborhood, perhaps the entire community, consistency with the comp plan, that it will not adversely affect the public health, safety, and welfare, that there are adequate public utilities to serve the proposed development, and that it won't have a negative impact on neighboring properties. And certainly one of the bigger debatable points when you, of course, are sitting in a public hearing and neighboring property owners are coming to you, telling you that it's going to exacerbate traffic issues, it's going to frustrate stormwater management issues, all the rest. And that's an important point, because when you're sitting in a public hearing and you're listening to the public with their concerns, and they are valid concerns, a lot of times you're not dealing with experts. It's the rare occasion that you actually get a neighbor who's a stormwater management expert. So you have to take those concerns into consideration. You have to make sure that the applicant is aware of those types of concerns. But you also have to weigh in your head what's opinion, testimony, and what is good, factually based testimony, perhaps based on expertise. And there may be the occasion that objectors come with their own experts who are there to refute the testimony being offered by an applicant. And then that can create a very interesting conversation that could include cross-examination of witnesses and things like that. So in that regard, it's very good to have a managed process with rules of procedure for how your commission operates. So let's talk a few minutes about ethics. You are public officials. You are appointed to your position by your municipality to conduct public hearings and serve as gatekeepers to ensure that the comprehensive plan is being protected, and the goals and objectives of the comprehensive plan are being advanced by different zoning applications that come before you. That can put a planning commissioner in an interesting position, not only with his or her neighbors, but also applicants themselves who may not live in the community. And you have to make sure that everything that you do as a planning commissioner is done in the context of the public hearing. And we'll get into this a little bit more, of course, when we talk about things like ex parte communication in a few minutes, but suffice it to say, there's laws in your states that you are subject to that ensure that you as a governmental official, and you need to think of yourself that way, is operating with the highest ethical standards, and that your actions are not somehow compromised by the actions of neighbors, the actions of applicants, or whatever. You sit in somewhat, if you think about it, you sit in somewhat of a judicial role because you're weighing facts and you're based upon the rules, you're making recommendations. In most cases, you're a recommending body, and then the legislature has final decision-making authority. It's certainly not true when it's in very from state to state, but that's something, but nonetheless, as an important part of the approval process for what people can and can't do with their property, you need to make sure that you operate at all times according to the highest ethical standards. And again, There are state laws across the country that govern that you are likely subject to. If you have questions about it, you should definitely talk to your local attorney. But it's all set forth to make sure that there's confidence in government and there's confidence in the process. And without these institutional controls in place, you can see where things could break down, and trusted government's a major issue right now nationally. And it's very important to keep your mind focused on these issues. And again, any questions can first be directed to staff and or your local attorney, depending on how communication flows through your government structure.
All right, so again, very broad, but hopefully gives you a little bit of a different point of view from what you usually hear from us around here, and gives you more of a national point of view. A lot of what he was talking there, I will say, is probably more about special use permits, which y'all currently don't review. But a lot of what he was talking about still can apply to general findings of fact with variances. So one other thing that I was going to show you. And thank you to Richie for sending this along. I know a number of y'all were able to attend the school government workshops, but several of you were not able to, so I just thought I'd go briefly through their presentation. Again, just trying to remind you, with the material that Raz has given you, as well as this, hopefully gives you, and especially for Ms. Anderson, gives you a good idea of what exactly your role is as Board of Adjustment. So again, there's generally three types of decisions when it comes to land use. There's legislative, quasi-judicial, and ministerial or administrative. Legislative is generally the planning board and town council. Ministerial, administrative is generally staff. And quasi-judicial is where you, as the Board of Adjustment, sit. Again, you're implementing standards requiring judgment, looking at variances, appeals, and it's limited discretion in your decision-making authority. For quasi-judicial decisions, again, as general statutes say, process of adjudicating how the general law applies to a particular situation based on an evidentiary record. They're your two key responsibilities: determining contested facts and applying standards that require judgment and discretion. As a Board of Adjustment, you sort of act like a court. That's why we call it quasi-judicial, because there are some rules that we follow that are very similar to court, but then there's some other things that we do that are different from court. As you can see on the screen, quasi-judicial decisions are not an opportunity to decide what standards should be applied, and they should not, and a quasi-judicial decision should not be based on public opinion. So the variance, which is one of the things that that this board reviews primarily, it's one of the things that you'll see the most. You'll see the four requirements that are sort of set by statute for variances is that one, and these are converted generally into our findings of fact for variances, but an unnecessary hardship would result from the strict application of the ordinance. The hardship results from conditions that are peculiar to the property, such as location, size, or topography. The hardship did not result from actions taken by the applicant or the property owner, and the requested variance is consistent with the spirit, purpose, and intent of the ordinance, such that the public safety is secured and substantial justice is achieved. You'll see here four things talking about with special use permits. Currently, this board does not deal with special use permits, so we'll move along on that. Certificate of appropriateness is dealing with historic preservation commissions, which we don't have a historic preservation district. Appeals of staff decisions, I believe we've had one since I've been here, and that is when you do review that, it's based on the facts and the law and you're determining what is the correct application of the ordinance to the case.
Ben, question?
Yep.
Currently, is it true that the only appealable administrative decisions are within the realm of planning, that it excludes, and per 160D, if I read the materials you handed out tonight correctly, probably been pushing that, that the administrative appeals are strictly for planning, that they exclude, for example, an appeal on a stormwater decision?
That's correct. The appeals that you as the Board of Adjustment here are appeals that are outlined in our Unified Development Code. So right now, under the current code, it would just be planning items. Now, I will say with our new Unified Development Ordinance we're working on through the Codify Clayton project, we are pulling stormwater, floodplain, and erosion sedimentation control into our overall code. And as part of that, there may be a couple of other appeal type cases that this board will be responsible for hearing. And I can't remember what those are exactly right now, but I believe, it may be stormwater may end up coming to you in the future. I know some of those, the stormwater, floodplain, and erosion sedimentation control, there will be some appeal language in the new code that will allow appeals to come to you, or if not you, there are some appeals for certain things that will go directly to the state as well. Another important note for quasi-judicial decision-making is just due process, having clear guiding standards, ensuring that notice is provided, ensuring there's an opportunity for all parties to be heard, ensuring you as decision makers are and remain impartial, making sure that the decision you make is based on the evidentiary record, and then of course there's always the right to appeal the decision. And one note on this, just for those that have been on the board for a little bit understand this, but Ms. Anderson, just for your knowledge, on the right to appeal, so the way we operate with this board, when you hear a case, most of the time you're able to make a decision on the case that night. Occasionally you will table it and make it and have the applicant come back with additional information, and it may take you 2 meetings to make a decision. But the way we operate is once a decision is made, you will make a verbal decision one night, and then the staff and the attorney will go back and write up the findings, the official findings of fact and conclusions of law document. And at your next meeting, that's when you will adopt that document. That document is a written decision. And so that document, once that's adopted, that is what will start the appeal timeline. So statutorily, it's 30-day, I think it's a 30-day period that you can appeal from a decision of the Board of Adjustment, because it takes us a little bit of time to get that official document created and passed by you. Folks actually have, technically have 2 months to appeal. However, they have to have that written document in order to actually file their appeal. So what we do tell applicants if they get a variance approved is that they can move forward based on that approval, the verbal approval. However, once that written document is created and passed by the board, that is what starts the official 30-day period for the appeal. So there is some risk for applicants if they move forward on a verbal appeal decision from the board. And then, once that written document is passed and created and passed, if a party appeals, after that time. But then once that 30 days is passed, the variance is law, and it does run with the land perpetually. So steps in the process for quasi-judicial decision-making. One, we have notices of the hearing, and that's, again, on staff to provide those notices. Anything that comes before you is advertised in the newspaper for 2 consecutive weeks prior to the hearing. We also send letters to all adjoining property owners within 100 feet of the property, and we post the property subject to the case. And so those are our 3 methods of noticing, as well as the information being placed on the agenda. We generally will work to get those agendas out, between 5 and 7 days before the meeting. And so that's yet another notice element. Once we start the meeting here, you'll have your hearing preliminaries. So you have your, any members who have conflicts of interest will recuse themselves. And again, our attorney, Raz, who sits with the board, will often, he'll help guide the board through that process. Then you hold your evidentiary hearing. Any witnesses, anyone presenting to you has to be sworn in. And then and generally, and I think it goes further on, and then you'll have the voting and decision, and then any appeal that may come after that appeal period. Talked about the notices. Bias. Again, board members cannot participate if a member has a fixed opinion that is not susceptible to change. So again, that's really a self-governed thing. But again, if an item comes up and you already feel that you have decided what it should be and you don't see anything that would change your mind, you really should recuse yourself. And then conflicts of interest, where you are required to recuse yourself, would be financial, relationship, or neutrality. And again, with neutrality, that discusses about ex parte communications. Again, with the quasi-judicial decisions and the type of things that this board hears, you are not supposed to talk to others outside about it. So, whereas with legislative items such as conditional zoning districts, staff will often tell applicants, talk to the town council, talk to the planning board. Make your case out. You can make your case outside of the meeting. You can talk to them and get their input before you ever see them. With anything that's quasi-judicial, such as special use permits or variances, the applicants are not supposed to have any communication with the board members. And the board members are not supposed to have any communication with themselves. You can always contact staff, but note that we as staff may be limited in what we can talk to you about as well outside of that hearing. Again, should be avoided. If you feel that you may have had ex parte communication, please disclose it. It doesn't necessarily require that you recuse yourself, but at least disclose it, and the board can always have a discussion, especially with the board attorney present, as to decide whether or not that you should recuse yourself. Common order for the evidentiary hearing, which I think we follow pretty much here. The chair will open the hearing. You'll have the introduction of the case or staff report by staff. And then generally the applicant will make a presentation. If there's any other parties present, the chair will provide them an opportunity to present their case. Again, they're supposed to be presenting evidentiary testimony. So we may get into it a little bit more, but again, Joe Blow neighbor is not, they may stand up and say, well, I don't like this because I think it's going to cause a lot of traffic, or I think it's going to ruin my property value. If they can't provide some sort of evidence to that fact or have an expert with them that can provide evidence to that fact, you can hear them out, but again, you should not take that into account as part of your decision making. So after you have any parties present or witnesses present, then the applicant will, and other parties may have an opportunity for rebuttal, and then that'll close. Then after that, the chair will close the public hearing and the board will deliberate and ultimately make a decision. As a reminder, all meetings are open meetings, and we are subject to the public records law of North Carolina. So again, anytime we meet, it has to be in public. It has to be open to the public. We have notice requirements, which again, staff generally takes care of. We have to have full and accurate minutes. There is for a board of adjustment, for advisory boards in general, there's very limited allowances for closed session. Again, staff would always defer to the board attorney if there's an item that comes up that may warrant a closed session or not. But generally speaking, this board will probably never have a closed session. And again, if you're at social occasions with other board members, try and avoid discussion of any public business that may be coming before you as a board. For public record, any record made or received in the transaction of public business is public record. So for this board primarily, if you have any emails that you create during board business, so that would primarily be if you're emailing staff or for some reason you have any emails to or from applicants, those technically would be considered public record. I would just say, hopefully any email you can keep just between you and staff or you and the board attorney. If for some reason you are ever contacted via email by an applicant, if you feel that you should respond, please copy staff on that response. Or you can also always just forward the email directly to staff and we can respond on your behalf as well. And again, these public records are subject to disclosure if requested. So building the record, again, as statute states, every quasi-judicial shall be based upon competent material and substantial evidence in the record. It should be trustworthy and reliable, related to the standards, and sufficient to support a conclusion. So they talk here about initial evidence. You have the application from the applicant. You have the staff analysis. If you as a board member do ever want to go make a site visit, you're certainly welcome to. It's not discouraged, but you certainly are not required to either. I know sometimes some board members may find it helpful to go and look at the site of a variance or the case you're hearing. As you'll see later on, just the recommendation is if you do that, try not to talk to the applicant while you're out there or others. And if you do, disclose it at the board meeting. So again, it is technically you have public hearings, so anyone present is allowed to present. However, they should be presenting relevant evidence. And then there's sometimes, occasionally you may get into a question of whether someone who is presenting information is technically a party to the case or not. That we will always defer to the board attorney to determine, but generally speaking, that gets into questions of whether they have standing or not. We generally don't have to deal with that too much, but every once in a while, we may have to deal with the question of standing, and at that point, we will defer to the board attorney to provide guidance for the board on that. Witness testimony, so again, they should be sworn in or affirmed, should be factual, focused on standards and land use impacts, and supported by firsthand knowledge or by documentary evidence, should not be personal opinion, and should not be focused on people. Expert opinion is required to rely on testimony regarding property values, projected traffic impacts, or any other technical matters. Again, for variances, primarily, you may run into, we do oftentimes talk about property values. But other than that, you generally don't get into other technical matters unless you're looking at special use permits, although I know we have had a variance before where one of the technical experts was a surveyor, and we got into some specific land questions around, I believe in that case it was around septic fields and whatnot, so. Again, you can accept written materials, and you will always get a packet of materials with the agenda for any cases you're hearing that'll include the application, staff report, and any other documents that we may be able to provide. Everything becomes part of the record. And then if, depending on the case, especially if you have an attorney present or representing the applicant, you oftentimes get additional material at the hearing as well. And all objections must be made at the hearing. So talk about outside evidence here. Again, ex parte evidence, just be careful. If you feel like you've had ex parte communication, make sure you disclose it. You can accept hearsay testimony, but cannot use as basis for key findings. Again, that's the, I believe that it's going to ruin my property value, or, I talked to Joe Shabobi, who said that it's going to ruin my property value. Again, Joe Shabobi's not here to present that information. So, and then the application, you can accept and use documents that are part of that application. Joe Shabobi shows up at the planning department quite a bit. He's one of our favorite customers. So, it's our version of Jane Doe. So. Just a quote from a recent court case. Again, in quasi-judicial proceedings, no board or council member should appear to be an advocate for nor adopt an adversarial position to a party, bring in extraneous or incompetent evidence, or rely upon ex parte communications when making their decision. One other note I'll make on this that you'll hear Raz talk about probably quite a bit is, during certain cases, I know he's had to talk, I know we've had this discussion with the council too on special use permits. Based on recent case law, this being one of them and some others, the North Carolina case law now generally has led to the point where the standard of evidence is generally seen, I think the wording they use is a scintilla of evidence. So the bar for providing evidence by the applicants is very low. What the courts have said is that in their view, as long as an applicant provides any evidence that they're meeting the findings, the board should approve the quasi-judicial decision that they're asked to approve. However, I think as board members, you still have the leeway to have discussion and decide if that is enough evidence for you. Now, our board attorney will probably always say, well, they've submitted something that is professional testimony and evidence, so you should let it go. You should view it on face. But again, that's a court standard. So it's one of those things where if challenged, if a decision of this board is ever challenged in court, the case law does lead to that, very low bar for evidence. And finally, when you're making your decisions and deliberating, it has to be an open session. That's why you're up there. That's why you have mics. Don't whisper to each other. You can't turn around away from the video and talk behind, your chairs. It has to be in public. You need to make sure you're pushing that button on your mic and that anything you're saying, any of your deliberations are caught and are heard by the public. Again, focused on applicable standards and based on evidence in the record. So generally, the applicant bears the burden to produce sufficient evidence to show standards are met. If there are opponents to the case, the burden shifts to them if the applicant provides sufficient evidence to support his or her case. The opponent then has the burden to provide evidence supporting their case or supporting the denial of the applicant's case. Occasionally, you may have to determine contested facts, such as for a variance, what makes the situation peculiar to the site. And that's where you'll do that through that deliberation. And again, you're going to be applying the standards. So again, for a variance, given the facts, is there an unnecessary hardship? Has the applicant provided enough evidence into the record to prove that they have an unnecessary hardship on their property? And then finally, when you make the decision and make the motion, you have options. You can, and the town council has done it both ways. If you're concerned that not all the board members will believe that all the findings of fact have met, you can go through and make a motion on each finding of fact and vote on each finding of fact separately. Or if it's pretty clear that everyone's on board with everything, you can make a blanket motion based on the findings of fact and the evidence in the record. And again, you can approve an item. You can approve an item with conditions. I will say, generally speaking, the conditions should be agreed upon by the applicant, or you can also always deny an application. And then in the decision, this is where the attorney will write up the findings of fact and conclusions law document. There will be reasoning based on the evidence and standards included. So occasionally, as you make a decision, you will have Raz, the board attorney, ask you to expand on your reasoning for why you are making that decision or why you believe a certain finding of fact is being met. For voting, simple majority for variance and most other matters. Simple majority for appeals and most other matters. For a variance, it requires a 4/5 majority. And absentee members still count toward members of the board, but we can exclude vacant seats and those with conflict of interest. So again, the bar for granting a variance is higher from a voting standpoint. And then finally, as I mentioned, there's always going to be a written decision. For us, we prepare it after the hearing. And again, it's usually prepared by either our board attorney or the applicant's attorney. It will accurately reflect the action and reasoning of the board, and then you will approve it at your next meeting, and the chair will sign off on that decision. Once the decision document is done, staff will handle getting it out to the applicable parties and filing it with the clerk as needed to start that appeal period. And as I said, 30 days from the date of the decision document is the appeal period. The appeals go directly to Superior Court and are based on the record that is in the file. Again, the record is the application, supporting materials, and then the record of the meeting itself, including the meeting video, in our minutes that staff take, and then any other documents that may be submitted. And that is that. So hopefully that gives you, for those that have been on the board a while, another refresher of what we do. I know we haven't had a case in a little while. And for Ms. Anderson, welcome to the board. And now you really know what you've gotten yourself into.
Can I have a copy of that?
Yes, yeah, I will email you a copy of that. So finally, just a few more other updates that I want to give the board before you adjourn tonight. Staff-wise, we are still down a position, so we've done some interviews, and I'm hoping that we can move towards putting an offer out here fairly soon. But again, we'll likely still be down a position for at least another month or so, likely till the end of the year. A couple of, and one thing I did want to mention, so several of you are involved in the Codify Clayton process and on the steering committee. We did present the annotated outline to the town council at their work session in October. We had a couple of specific questions, one of which we asked them was if they were open to, in the new code, in the new UDO, having the Board of Adjustment be granted the authority to hear and decide on special use permits. Because currently you handle variances and appeals, which are quasi-judicial decisions. Town council handles legislative decisions except for special use permits, which are quasi-judicial. And town council has some difficulty, as elected officials, they just have some difficulty sometimes with having to have those guardrails of a quasi-judicial decision. So they were open to that. And so as we are moving forward with drafting, we are going to be drafting the code to have the Board of Adjustment be the decision makers for special use permits. There will be a lot fewer special use permits than we have now. So I don't necessarily think that your caseload will increase dramatically, but it will, the goal and the way we presented to council, and assuming they ultimately agree to the final code, the goal would be that all quasi-judicial decisions would be placed with this board because you're trained in it, and those are the types of decisions that you do. Whereas, the town council, they have training for it, but they're more used to the legislative decision. So more to come on that, but I did want to put that out there. So again, we'll have drafts of the Unified Development Ordinance starting to come out here over the next few months. So as you may see or hear about the drafts, if that comes up, just be aware that that is something that we've proposed and council has preliminarily said okay to. So just some reminders for dates. December 6th, there's the Advisory Board Appreciation event that the town is holding. I hope everyone has received an invitation from Heidi. I'm not sure if you have yet or not, but hopefully you will, Ruth. I'll talk to Heidi about that. It's going to be held over at Brick and Mortar at 6 p.m. on December 6th. It's always a really nice event, so hope to see everyone there. And then the December 14th, we will have a Downtown Master Plan Update public meeting. It will be here in this chambers. It'll be primarily based on two parts. One, education of, again, what the Downtown Master Plan Update is, and an overview of what we've done to date, and then also providing an overview of the public engagement that we've gotten, and all the input we've received to date. And then coming out of that public meeting, we will be identifying some opportunity sites in the downtown area that our consultants will then draft up some concepts for those opportunity sites, and we'll hold some additional public engagement opportunities after the first of the year where we bring forth some of those concepts and also start bringing forth drafts of the plan. So again, if you're interested, please feel free to attend on December 14th. It'll be from, I expect it to be 6 to 8. I think is what we're looking at, and probably more of a drop-in type session. So, and then that same week, either December 13th or December 15th, still waiting to confirm with our consultants, we will have a Gateway 42 plan meeting, which is our other small area plan we're working on, covering the area centered around the US 70 bypass 42 intersection, looking on either side of that from Amelia Church Road out to Cornwallis. That meeting will be held, again, either December 13th or December 15th. Likely will be around that 6 to 8 timeline, and it'll be out at the community center on Amelia Church Road. And again, our consultants will be here. We're hoping to get some good input from stakeholders in that area specifically. Staff attended, Bruce and I attended the Harvest Festival all day on a few Saturdays ago with our consultants for both the Downtown Master Plan update as well as the Gateway 42 plan meeting or plan, and did public engagement at the Harvest Festival, and we got really, really good input from that. So we're really excited. We found out that there's a lot of people that want a Chick-fil-A here in town. Surprise, surprise. And there's a few that think we should have a Wegmans. And then, let's see, were there any other interesting? Yes, Target and Home Goods were also two big winners. So we'll see where that goes. But if you're interested in learning more about the Gateway 42 plan, which we've recently branded the Gateway 42 plan, we do now have a website. I believe it's gateway42.com is the website. There's a survey up there that you can fill out, and then also see a little bit more information about the plan there. So again, even though you are the Board of Adjustment, I want to make sure you're aware of everything that's going on in the world of planning. And again, feel free to attend any of these meetings as you're able and want to. And with that, I think that's all I have. As far as items that we have in the hopper for the board, currently we do not have any. So if you would like to cancel your December meeting, you may do so.
One quick question, just for clarity. The 13th is the Chamber's annual meeting.
Okay.
So there may be conflict with people wanting to attend that and the Gateway 42 meeting.
Okay.
Since that's one of the dates.
Thank you.
I have a quick question real quick for you. So the December 14th meeting, is that going to be here or is that going to be in the community building off Amelia Church Road?
The December 14th meeting will be here.
Okay.
It's the December 13th or December 15th meeting, whichever date we choose, which sounds like we'll probably try and aim for the 15th, will be out at the community center on Amelia Church Road.
Okay. And just one more thing, and thank you very much for letting me go to the training for the UNC. It was very informative. It was about 3 hours long, about 2.5, 3 hours long, but it was very informative. So thank you for letting me the opportunity to go. So appreciate it. Thank you.
Any other questions for Ben? Thank you, Ben.
right, thank
Appreciate
you.
the training and the update. It sounds like there's no lack of activity in the planning department right now. So appreciate all you're doing and keeping us informed. Any other discussion or comments from the board you'd like to talk about?
Do you want a motion to cancel December?
We can do that, Ben. So there's no way it's not too premature to cancel at this point. Absolutely.
Move to cancel our December meeting in the absence of any material to cover.
We have a motion to cancel the December Board of Adjustment meeting. Do I have a second?
Second that.
Have a second. Any discussion? Okay, all in favor, say aye.
Aye.
Opposed? Motion carries. All right, with that, brings us to adjournment. I'll entertain a motion to adjourn.
Motion to adjourn.
A motion, to have a second?
I'd like to wish everyone a great Thanksgiving and a Merry Christmas.
Absolutely, absolutely. Was that a second? We'll accept it. Any discussion? All those in favor to adjourn, say aye. All opposed? Good evening.